On today's show, the bullet point, our top 4 topics in the areas of news, technology, politics, and entertainment. Choose the one you want to hear the most by visiting our Mastodon page at mastodon.vtip.me/@what-you-missed. Choose one out of the 4 and I'll read it for you live. Then, breaking news in the areas of politics, national and international stories, live on air as it happens. Plus, the most interesting articles I can find from the Washington Post, CNBC, Variety, Business Insider, The Hollywood Reporter, and more. Then, a moment of Krug, a Paul Krugman op-ed that is a must-read. All of that and what you may have missed in the news today. Stay tuned. Welcome to today's show. I am your host, Eric Darnley Small, and I want to thank you very much for joining me. If you're joining me live right now, it is 10:36 Eastern Standard Time, New York time. Normally, we would be streaming live on YouTube and stream.vtip.me. However, I think there is an technical issue with my stream.vtip.me, so you should be seeing me on YouTube, which according to what I can see, YouTube is functioning fine. My own website, however, is on the blink. There was an update fairly recently with the software that runs that, and unfortunately I think it may have broken something, so I haven't had a chance to check today, and I will at some later date. Also, I hope you guys know that you can reach out to the show as well as to me at mastodon.vtip.me/@what-you-missed, and there you will find links. If you've been to this channel before, you'll know that I'm going to talk about some stories that you may have missed in the news. And one of the things that you should know is that I don't read the full story because of time. And also, I want you to go and I want you to check out these websites on your own to take a look at. But you'll find the full links at the Mastodon at mastodon.vtip.me. And so you can see everything that I've been seeing and talking about today. Look at it for yourself. You'll find the full article with links. I abbreviate the articles for the purposes of time and to get things moving here. So let me show on today's show what we're going to be talking about. We're going to be talking about this hearing right now because it is happening right now on SCOTUS. Supreme Court of the United States is hearing oral arguments on whether states can criminalize homelessness. This affects many states. We know that California right now has a huge homeless problem. I think it's the worst in the nation. But New York, you have Texas, Florida, other states. And the solution these right wingers, and particularly in the red states, have decided is to throw people in jail for being homeless, or criminalize them, which is, I think, a somewhat bizarre response because putting them in jail is just basically housing them. And can the taxpayer really afford that? So whatever. But anyway, a lot of states have decided to try and pass onerous laws to penalize it. I was reading one story about how in parts of Canada, they've decided to put spikes in the seating areas near stores and whatnot to keep people from laying down comfortably in front of their store. So there are a lot of different states, a lot of different countries are addressing the issue of homelessness in a lot of different ways. Right now, this is about the state of Oregon passing a law to ban homelessness. I'm going to talk about that because that is should be happening right now. Oral arguments in the Supreme Court. In addition, I'm going to be talking about how a state court in Indiana has sided with Jewish Americans against state law, because in the state you cannot have abortions except with a bunch of other restrictions are thrown in there. But abortions are illegal, like in a lot of red states. However, for a bunch of Jewish folks, and I'm going to read about this, decided to challenge that law because their religion allows for abortions. And remember, the abortion issue or the anti-abortion issue is a, sort of a mixed bag of, but mostly it's about religious belief that the unborn need to be protected, turned into legal doctrine. So then we've got the national popular vote in Maine. I haven't talked about that a lot in a long time. It's fascinating on a number of different ways, and that is, can liberals or can folks on the left deal with this issue of um, the electoral college, wherein states that have 5 people in it have as much voting power as states that have, thousands, because of the electoral college. So, of course, I'm exaggerating with regards to those numbers. And then finally, a very interesting story out of the New York Times from a few weeks ago about a guy who stopped what could have been one of the major cyber attacks in the U.S. The reporting on this is that this was a huge deal. It could have been a huge deal if it wasn't for this guy's action. So, but first, we're going to begin with the oral arguments today on the ability for courts to criminalize homelessness. And the title of this one is Supreme Court to decide whether politicians can criminalize homelessness. And this is from the Rolling Stone online, April 21st. That's yesterday, by Jeremy Childs. This is sort of, these oral arguments should be happening today. And this is a story that affects a lot of people, a lot of places. Again, full links at our Mastodon. So, and it begins with, it says, the case pushed by left coast cities and conservatives alike ask whether it's cruel and unusual to punish people who sleep on public property. And it goes on to say the Supreme Court on Monday, that is today, will hear oral arguments in City of Grants Pass v. Johnson, a case that could essentially determine whether homelessness can be criminalized. The case stems from the city of Grand Pass, a town of roughly 40,000 in southwest Oregon, which began enforcing ordinances in 2013 that made it illegal to sleep on public property using bedding, which could mean anyone using a tent, sleeping bag, or blanket to make it through the night. Let me just say, this is me editorializing. This is happening right now this is a case dealing with Oregon. We've been talking a lot about Oregon. Oregon's becoming a very fascinating place as to a lot of things. It's a blue city, liberals sort of run the show there, like Washington State, California near there. But they're doing a lot of things that are, turning out to be maybe not that great. One of these, and in these blue states, you've got red pockets that are trying to run their own agenda, and the state is trying to stop it or make changes. I've talked about in previous video, I think 2 weeks ago, the drug problem in Oregon because they relaxed all their drug laws, and now we've got this homeless issue that they're attacking. And this is interesting because it's happening right now in Florida. It's happening, and in other places they are trying to ban people from sleeping in the streets. The city was sued by a group of homeless residents, and a federal court ruled in their favor, arguing that laws against camping were unconstitutional based on the Eighth Amendment protection against cruel and unusual punishment. The U.S. Court of Appeals for the Ninth Circuit sided with the lower court in a 2-1 decision. Grand Pass then appealed to the Supreme Court. Supporters of Grand Pass case include many conservatives who seek to remove homeless populations to boost public safety, as well as liberal leaders in West Coast cities overwhelmed by a spike in homelessness as rent prices soar. Governor Gavin Newsom of California was among the high-profile figures to file an amicus brief in the case. The United States Supreme Court can establish a balance which allows enforcement of reasonable limits on camping in public spaces while still respecting the dignities of those living in our streets, Newsom said in a statement last month. Opponents of the case, however, fear that the Supreme Court ruling expected in June could open the floodgates for jurisdictions cracking down on homeless populations. Quote, if the Supreme Court were to allow for such punitive regime, then we're going to have a race to the bottom to make it as uncomfortable as possible for people to survive. John Dew, a senior staff attorney with the American Civil Liberties Union in Northern California, tells Rolling Stone. Boise, Idaho was another city that effectively outlawed homelessness via anti capping laws until the city was sued in 2018. The case Martin versus Boise reached the Ninth Circuit in 2019. The court ultimately ruled that residents without permanent shelter could not be arrested only because they were homeless, limiting how cities can respond to homeless encampments with enforcement sweeps. The decision caused leaders in cities overwhelmed with homeless residents like Los Angeles and San Francisco to side with conservatives in their support of Grand Pass case. Dew also explained the legal arguments underpinning the Grand Pass case is not just about homelessness, but whether people can be criminalized for their status instead of their actions. One of the big questions heading into today's oral arguments is whether the Supreme Court justices view being homeless as voluntary or involuntary, which was the case with the points raised by the Justice Department in a brief in support of neither party in the case. Quote, I think there may be a lot of questions on whether or not homelessness is voluntary or involuntary, Dew says, which he describes as a really troubling framing. So that is very, I find this very interesting on a number of levels. Number one is this is a situation that affects both Democrats and Republicans. You have states, blue states that are really, California primarily, that are really being overwhelmed by the homeless situation. Of course, you've got this rent issue where the rent is so expensive, particularly in San Francisco and those other places, that people have been, become homeless, as well as, there's a whole lot of stuff, and I've talked about this before, and I will bring this back up in other episodes. But we've got to really look at what is happening with respect to banking, with respect to commercial real estate, and then how that's going to trickle down. We know inflation is still an issue, and we know some people are not buying homes, they're renting, or they're not looking to sell their home because they still have a mortgage that you can't get those rates anymore. It's so they're so low. So this really attacks and this really affects a lot of different areas. We've got situations here in New York where you've got squatter issues here. You've got issues of tenants' rights versus owners' rights. This really hits on a lot of different areas, and I'm very curious to see what ends up. Would be precedent setting because of the implications, and depending on where the Supreme Court ends up on this. So moving on. This is fascinating on a number of different areas and a number of different levels because it has the tendency or the possibility of pitting the conservative movement, which is in love with being anti-abortion, with Jewish Americans who, in their faith, allow for abortions. So here you have two major religious groups that have a difference on this particular issue. And because of this issue, they're going to court and they're going to be both, in a legal battle and I think in a political battle in certain states with the Republican Party. Now, parts of the red, more, I guess, militant, you could say, part of the Jewish movement sides with conservative, sides with the Republicans. For instance, in the Gaza situation right now, the more and more are siding with Republicans on doing everything you can to assure that the Jewish people have a state in Israel. And I've gone over the reasons why they're bedfellows. But here there's a opportunity for there to be division. Remember, a part of the Republican Party that is ascendant is a white nationalist, racist part that abhors Jews. They think that Jews are the worst, and that is part of the base of the current Republican Party. So you already have within the party a division based on anti-Semitism. I talked about on my last video 2 weeks ago about this Christ is King business amongst right-wing influencers and how they're starting to shoot barbs at one another over the issue of Israel and Gaza, similar to on the left, but for different reasons. But this is could become another breaking point between the right in the conservative movement in the U.S. and the right in the Jewish movement in the U.S. And this article reads: an Indiana court ruled that Jews have a religious liberty right to abortion. Here's why it matters. And it goes on to detail. It says the ruling presents a persuasive case for other states' courts to follow, potentially opening the door for Jews and other similar religious commitments to secure abortions. That could be very problematic for the religious right. So this is from the Jerusalem Post online, April 12th, 2024, by Michael A. Helfand. And it goes: since the Supreme Court's 2022 decision, Dobbs v. Jackson, a woman's health organization, the right to abortion is no longer protected by the 14th Amendment. But that seismic constitutional change has triggered a new legal debate. In the absence of federal constitutional protection, does state law provide Jews with a religious liberty right to abortion? Last week, an Indiana state appellate court answered yes to the question, invoking variations of the word Jew more than 70 times in the process. As the first state appellate court answers the question, the ruling presents a persuasive case for other state courts to follow, potentially opening the door for Jews and others with similar religious commitments to secure abortions that are motivated by religious values, even where such abortions are otherwise prohibited by state law. The idea of a Jewish right to abortion being enshrined in U.S. law at first sounds strange. But in the wake of Dobbs, as states have adopted new abortion restrictions, Jews and Jewish organizations have filed suit arguing that those restrictions put them in a bind. Jewish law's approach to abortion is generally understood as much as anything within Jewish law is, quote, generally understood, to place the well-being of the mother, including physical and emotional well-being, at the center of its analysis. Again, I'm going to repeat that again. Jewish law places the well-being of the mother, including physical and emotional well-being, at the center of its analysis. As a result, where an abortion is necessary to protect the well-being of the mother, broadly constructed, Jewish law sanctions and often requires the termination of the pregnancy. If a mother motivated by these underlying Jewish values were to seek an abortion in a state that imposed significant restrictions on such procedures, her religious commitments could run afoul of state law. So what they're saying here is basically Jews have a religious right to an abortion, a part of their religious doctrine, right? So this is extremely significant, and this is the first court to argue or to hear this on a state level and make a decision. But here's also what is key about this, which is fascinating. So it goes on to say, the plaintiffs in the Indiana lawsuit, which include both individuals as well as the organization Hoosiers Jews for Choice, are not themselves pregnant, but a number of the individual plaintiffs allege that they would like to become pregnant through assisted reproductive technologies or otherwise, but they fear, given past histories and the realities of using assisted reproductive technologies, that the Jewish commitments may require them to undergo an abortion. And given that Indiana's restrictions might prohibit such actions, they have held off becoming pregnant. So this is what in the sort of, in this space, the legal and political space, calling chill. This is what it means to chill something, right? You'll hear, for instance, chilling speech, or in this case, it's sort of chilling abortion. And what a chill is legally is basically just what they've defined, is that a law is passed, and the fear of being in violation of that law prevents a person from acting what would normally be legally, so or would normally be protected. So an infraction hasn't happened yet, but because of the law being passed, it has chilled their desire to take that action because they fear litigation. And you'll hear this a lot about, and it's a little bit dubious, I think, because normally you, in order to bring an action, you have to have damages. In other words, something, you have to have been sued, or you had to have been told you can't do something or whatever in order for it to be legal, in order for a court to hear it. However, the idea of chilling means that you would do this action, but except for the fact that you understand this law, and it could be in a case where the law seems opaque, or it seems like very confusing as to whether it's you would be sued or not. But because there's either confusion or because the law exists and you understand the law to be that if you take on this, what you believe to be constitutionally protected act, if you take on that act, you could be sued. So you don't do that action. And that is something that has been in the court, and I think right wingers have used that for years to strike down or to attack laws that they don't like, because even before they've actually performed that law, performed that illegal, what would be illegal action. So, and again, you hear a lot of that when it comes to speech. You'll hear the term chilling speech. So that to me is the clearest definition of what a chill is. When a law is passed and it's so-called chilled any kind of action, this is the decision, or this is a description of what that looks like. And again, it is this idea that because they have passed this law, that these folks would like to become pregnant, but cannot be, but can't risk, or don't want to risk being sued if they do become pregnant through in vitro fertilization, and then that pregnancy fails and they have to have an abortion. But they believe that if they did, they would then be sued, so they're not even trying. And it's illegal. The courts have seen chilling an action, if they deem it to be constitutional, is illegal, and would strike down that law before it even takes effect, or before anyone even breaks that law. So, and it ends with an Indiana Court of Appeals found that under such circumstances, the state's religious liberty protections are likely to require proving women in such circumstances with a religious exception from the state's abortion restrictions. The logic of the court's decision is pretty straightforward. Indiana, like over half of the states, have broad religious liberty protections captured in the state's Religious Freedoms Restoration Acts, or RFRA. RFRA, as an initial matter, prohibits the state from substantially burdening religion. Applying this rule, the Indiana court found that the state's abortion restrictions, by prohibiting abortions motivated by Jewish law, and therefore discouraging the plaintiffs from becoming pregnant, imposing a prohibited burden on the religious exercise of the plaintiffs. The state, however, argued that this burden on religion was justified. Indeed, RFRA allows the state to justify imposing a burden if doing so is the only way to achieve some sort of essential government objective, or in legal terms, if the burden is narrowly tailored to achieve a compelling government interest. To make this argument, the state contends that protecting fetal life is a vital government objective, vital enough to overcome religious liberty rights of the plaintiff. The court ultimately rejected this argument. Indiana's abortion restriction, it turns out, has a lot of other exceptions. I just want to point out in this, I'm going to editorialize before I move on, but here you have the state arguing against what these states have been traditionally arguing for. Remember, the abortion, the idea that life begins at conception or begins in the uterus, that person should be considered a full born a full live individual like an adult or a somebody who has been already born a child, that exists within them comes from religious belief, right? There's no medical evidence. There's no, doctors or whatnot that believe an embryo is equal to a child, an actual born child. But it's because of religion, the religious belief that is happening, that laws are being passed and the courts are siding with a religious belief that indeed life begins in the womb as soon as conception or very close to it, and that abortions would be illegal because it would be murder of a child. Here, however, the state is arguing that we have a right, as the government, to overcome religious liberty, RIFRA, as it's known. And here, the government is arguing, and this is Indiana is pretty much a red state, is arguing against religious liberty. So here, the conservative have taken the opposite side, normally the side that the liberals would take, in saying that the government interest and the interests of the people overcome a religious belief here. Normally, that is not the side of this argument that they want to take, but because they cannot use the religious liberty aspect of this, they're being attacked from a religious liberty standpoint, they have to take the side that they normally are against. Absolutely fascinating, situation that these conservatives have found themselves in, but the court's not buying it clearly. So this article ends with, so where does this leave us? The decision will presumably be appealed to the Indiana Supreme Court, and it's no doubt possible, either for procedural reasons or otherwise, that the Indiana Supreme Court will reverse the decision. But for now, the fact remains that the first state appellate court to analyze the issue interpreting state religious liberty law to protect the right of Jewish plaintiffs to religiously motivated abortions. The decision may well have broad impact. Because these cases focus on state law as opposed to federal law, they won't be heard by the United States Supreme Court. That means litigation over a Jewish right to abortion will be fought in state courts around the country. Other state courts are likely to take notice of this judicial foray into the issue, especially given that over half the states around the country have identical or nearly identical religious liberty laws. With an easy-to-follow blueprint now available, last week's decision may signal that a Jewish right to an abortion is no longer merely a theoretical argument. It may, in a world without Roe, be the way of the future. So this is one thing to keep an eye out on, to keep looking at, because this has legs, and I think it has a lot of significance, both on the ability for Jewish, particularly, like I say, right-wing Jewish people, to hang in there with the Republican Party, which is anti-Semitic, and in addition, now over abortion issues, one of their main issues, they are now going to have to deal with a party that wants to take away abortion rights, which, according to Jewish law, women have a right to. So it's strange bedfellows. It's a fascinating, interesting look. This is a state reversing itself, arguing for basically the government has a right to overrule a religious liberty, even though that a law is based on a religious belief and religious rights. So the conservative court is not buying it in Indiana. We will see with the Supreme Court how conservative that is and see how things move forward going from there. But something to keep an eye out, and I will keep an eye out on this going forward. Next up is this very interesting thing, and I talked about this not at all on this channel, but on my previous podcast that I had a number of years ago, The World as I Like It to Be. And this is a case about something on the left that has been brewing up since, I think, Donald Trump won in 2016. This is an article that says, state law takes U.S. a step closer to the popular vote deciding presidential elections. This article goes into the history, so I'm not going to go into too much history on it. I'll have the article. I'll read from the article. But basically, for the longest time, Democrats have been winning the popular vote when it comes to the presidency, but losing the presidency, and it's been somewhat of an issue that goes actually back to Bush v. Gore, as I recall. This idea that we have to change the Constitution, the idea that the Electoral College is giving a handful of states all the power to elect a president. We need to get rid of this thing. It's antiquated. Republicans keep losing the popular vote. And really, we should be voting based on a popular vote, whereas, of course, Republicans say that that's not true, that's not constitutional, and we're not looking to change anything. I'm going to give my sort of feelings on this at the end of this. But so the solution that the left has come up with is this whole national popular vote. I'm going to go into that. The article goes into that in a moment. But it says Maine is the latest state to pass the national popular vote legislation law. And this is from ABC News Online. This was yesterday, April 21st, 2024. Nadine El Bawab, I assume. I'm sorry if I'm butchering your name. But this is her report, and it goes into, and I haven't talked about this because it's kind of been silent lately on this whole thing. I haven't heard a lot of states moving on this. But anyway, let's go into it. So it says, after much public debate, a Maine law has brought the country closer to having the popular vote determine the winner of the national presidential election. But it's unlikely that it will happen before November or even at all. Earlier this week, Maine Governor Janet Mills allowed a bill to become law without her signature that would take effect once the National Popular Vote Interstate Compact is able to gather pledges for at least 270 electoral votes, the number of delegates voters need to elect a president. The movement is now gathering pledges from 17 states and Washington, D.C., accounting for a total of 209 electoral votes. So what this is saying is basically the law won't kick in until the national popular vote can get pledges of at least enough states to equal 217, which is the number you need to elect a president in the Electoral College. What this is basically saying, which is very interesting, is that this law won't kick in until a number of states that equal 217 electoral votes have signed on to this pact. This is kind of what Republicans do and have been doing for years as it pertains to abortion rights, right? They say, we're just going to put this law, we're going to bank it, and if Roe ever falls, this law will automatically kick in. I wonder about the constitutionality of that, but that's what's happened all across the nation. That's why you have so many states that have automatically, instantly switched into these anti-abortion laws. It's not that they had a bunch of hearings or they did this all overnight. It's that years ago, sometimes I think even decades ago, the state had passed laws that basically said, if Roe ever falls, this new law kicks in. So that's basically what has happened here. Interesting way to go about passing laws. But anyway, to continue on to the article, the National Popular Vote Interstate Compact seeks to guarantee that the candidate who receives the most popular votes in all 50 states and the District of Columbia wins the presidency. When there are enough states pledging their popular votes to meet 270 Electoral College votes threshold, all the votes in those states will be added up to a national count that determines the winner of the election. The National Popular Vote Interstate Compact says that it will give each vote equal weight regardless of where the voter lives. 5 of the 46 presidents who came into office lost the popular vote, including Donald Trump most recently in 2016. The compact argues that not every vote is equal under the current system. Darrell West, a Douglas Dillon chair in government studies at the Brookings Institute, said the country currently only has a handful of swing states because of the Electoral College. So candidates spend most of their money in that small number of states. But it remains unclear what happens when enough states pledge their delegates. Quote, There's a lot of deep legal consternation over what happens next. I mean, in my judgment, I think it needs congressional consent, unquote. Derek Mueller, law professor at Notre Dame Law School, told ABC News. If Congress fails to do that, I'm sure there will be litigation, Mueller says. Notre Dame, I think, by the way, is kind of a right wing law school or state. I don't know. I'm speculating. I know that I'm speculating. But anyway, moving on to the article. There are other legal questions, such as whether it would violate equal protections if the U.S. were to have different states with different rules in their elections, and questions about whether a state has the authority to do this, Mueller said. West agreed that the legal situation is unclear, but, quote, it's not obvious that the status would be of those laws. It's not obvious what the status would be of those laws. States do have the authority to set election laws, but according to the Constitution, the electors to the Electoral College actually are free to vote the way they want. Hold on to that idea. The idea that electors to the Electoral College actually are free to vote the way that they want, because I actually think that that's not accurate. There was, and I'm going to talk about this when this article is over, but this is the idea of whether electors are free to vote any way that they want has been challenged. But anyway, let me move back to the article. So it remains unclear whether this is constitutional. And it says, quote, and so states can pass laws, but there haven't been a lot of cases testing these provisions. And so it's not clear how the Supreme Court would rule on this issue. Mueller said if a state sues another state, the case would go directly before the Supreme Court. About 100 years ago, before the 17th Amendment was passed, which allows for direct election of senators, states had begun shifting from legislatures choosing members sent by the state to the U.S. Supreme Court to having, quote, preference polls for the public where they would signal who they want to represent the state. Later, those states, including Oregon, began binding themselves to the results of the preference polls, Mueller said. He pointed to this as an analogy in which the states were trying to, quote, convert legislative elections into the popular vote, even though there was no formal mechanism to do so. Eventually, the Constitution was amended to make Senate seats elected by popular vote. West argues that the direct election of senators did require a constitutional amendment to go into effect. Some states unsuccessfully tried to implement term limits for members of Congress. About 20 to 30 years ago, Mueller said, the Supreme Court said that it was unconstitutional in 1995. So Missouri tried something a little more creative, which was to say, okay, we're going to ask all candidates to make a term limits pledge, and we're going to print, if they violated the pledge, we're going to put that on the ballot. Or if they decline to support term limits pledge, we're going to print that on the ballot, Mueller said. The goal was to say, well, we're not keeping you off the ballot. We're just telling everyone whether or not you adhere to term limits, Mueller said. And the Supreme Court said, well, you can't do that either. So this idea of mucking around with the Electoral College and how that's done is not something new. This is actually something that is Donald Trump tried to do, and he's right now the whole fake electors, the whole being on trial for storming the Capitol and all that kind of stuff. All of that was around mucking and messing around with this idea that states can decide on their own who can decide. States deciding on their own what electors are able to decide who the president is, right? It was called the fake elector scheme. And there's a lot of reporting on that. You guys can take a look at that. But I just want to bring up this one story because this is how the left, 2 points I want to make here. This is how the left fights. And let me just say, I think this is totally dubious. I think this is absolutely going to be, this electors thing is going to be absolutely eviscerated by the Supreme Court. They're not going to support this whole idea. This is a bunch of geeks getting in a room thinking about, scratching their heads, thinking about what they can do. But the Republicans do this all the time. And I was recently reminded of a quote by Clinton, who said the people want to at least see you fighting and see you going down fighting. And this is what we don't get enough of from the Democrats, from liberals, progressives, is they don't see it. Well, not from liberals and progressives, actually from Democrats, from the politicians. We don't see them fighting. And we need to start seeing Democrats fight. And the quote unquote, again, I'm going to use the geek side, these guys who are, Heritage does this on the right all the time. And they're sitting around and a lot of the conservative, I can't remember the name of the conservative group that elects all these guys. But that's all they do all day long. And we know about Project 2024 and all that kind of stuff, where these guys are going to rush through crap through the system to try and, put through all these theories into law and get these conservatives and these judges and electors to do it. But let me just talk about for a moment how the right tried to do the same business with the Electoral College by changing the Electoral College without actually changing the Constitution, right? They mess around with this kind of stuff. And again, I can appreciate the desire to be caught at least fighting, but we got to be very careful on this whole thing. Let me just do this so I can bring this up. Okay, we got to be very careful in trying this, because I really do believe that this is something that is not going to go anywhere if we get to the Supreme Court. And I think that folks are somewhat deluding themselves if they think that they will be able to get by this. I'm sorry, I'm holding off on doing anything because my, there we go. I couldn't get rid of my thing. All right, so I want to just take a look at this. This is the fake electors, and the Republicans tried this some time ago, and this is from July 2020. And it says, and it asked the question, this is from the NBC News, written by Pete Williams, who is retired, I believe, no longer on NBC. The 538 people who cast the actual votes for president in December as part of the Electoral College are not free agents and must vote as the laws of their state districts, or their state directs. I'm sorry. I'm going to read that again. The 538 people who cast the actual votes for president in December as part of the Electoral College are not free agents and must vote as the laws of their state direct, the Supreme Court ruled on Monday. The unanimous decision in the faithless electors case was a defeat for advocates of changing the Electoral College, who hoped a win would force a shift in the method of electing presidents toward a national popular vote. But it was a win for state election officials who feared that empowering rogue electors would cause chaos. Writing for the court, liberal, by the way, the liberal justice, this is me editorializing, it says, writing for the court, Justice Elena Kagan said the Constitution gives states far-reaching authority over choosing presidential electors that includes the power to set conditions on an elector's appointment. Quote, that is to say that the electors must do for the appointment to take effect. That is to say what the electors must do for the appointment to take effect. What's more, she wrote, nothing in the Constitution expressly prohibits states from taking away president-elector voting discretion. The ruling aligns with, quote, the trust of the nation that here we the people rule. So this to me would be very clear evidence that this idea of the national pact that the Democrats, or that the, I'm going to say liberal think tanks are trying to push through is clearly unconstitutional. But again, this is something that the right has been trying to do for a long time, trying to create, these ideas that you can do an end run around the people in the way the people vote with these crazy sort of viewpoints. Trying to get around the Electoral College, which people believe are problematic. Republicans only just recently believed it was problematic thanks to Donald Trump. but the left has been talking about has been problematic for a long time. But because no one can change the Constitution, they're trying all of these indirect, fancy dancy, legal maneuvers to get around changing the Constitution, getting rid of the Electoral College. And I don't think the Republicans, certainly not that, and that is the lesser conservative because Ruth Bader Ginsburg was on that, and now she has been replaced by Amy Coney Barrett. So I think that this is going to show that the court is even going to be less inclined to help out Democrats and help out this idea of using trickery, what I would call trickery, with this whole electoral compact to have everybody sort of sign together that they'll promise to vote the direction of whatever the national public, whatever the national popular vote says, as opposed to how the people in their state decided who they wanted to be president. I don't see it happening, but you want to see people fighting, at least die trying. So finally, this is a story that is kind of, this isn't, I don't think it made big news, but this is in the tech space, which I, of course, love, and this is a little bit of a story of a personal interest to me. But if this had not, if this had gone a different way, everyone would be talking about it. Why? Because your Facebook and your MySpace, not MySpace, good Lord, your Facebook, your Instagram, your TikTok would be down and out. Because if this had happened, the internet would be compromised. And it's basically a story from the New York Times which said, did one guy just stop a huge cyber attack? And the story goes into a very, I don't think very at all discussed that I've seen story of how this sort of, random guy looking on the internet found a bug that may have been planted. A lot of fascinating things in this, but let me go into it. And it says a Microsoft engineer noted something was off on a piece of software he worked on. He soon discovered someone was probably trying to gain access to computers all over the world. This is from The Shift, New York Times, The Shift, April 3rd, 2024, by Kevin Roos. And it goes, the internet is a messy patchwork that has been assembled over decades and is held together with the digital equivalent of scotch tape and bubblegum. Much of it relies on open source software that is thankfully maintained by a small army of volunteer programmers who fix the bugs, patch the holes, and ensure the whole rickety contraption, which is responsible for trillions of dollars in global GDP, keeps chugging along. Last week, one of those programmers may have saved the internet from huge trouble. His name, Andres Freud. He's a 38-year-old software engineer who lives in San Francisco and works at Microsoft. His job involves developing a piece of open source database software known as PostgreSQL, whose details would probably bore you to tears if I could explain them correctly, which I can't. Recently, while doing some routine maintenance, Mr. Freud inadvertently found a backdoor hidden in a piece of software that is part of the Linux operating system. The backdoor was a possible prelude to a major cyber attack that experts say could have caused enormous damage if it had succeeded. The saga began earlier this year when Mr. Freud was flying back from a visit to his parents in Germany. While reviewing a log of automated tests, he noticed a few error messages he didn't recognize. He was jet lagged and the messages didn't seem urgent, so he filed them away in his memory. But a few weeks later, while running some more tests at home, he noticed that an application called SSH, which is used to log into computers remotely, was using more processing power than normal. He traced the issue to a dataset compression tool called UXUtils and wondered if it was related to the earlier errors he'd seen. Like other popular open source software, Linux gets updated all the time, and most bugs are the result of innocent mistakes. But when Mr. Freud looked closely at the source code for XZUtils, or utilities, I think that's what's short for, he saw clues that it had been intentionally tampered with. In particular, he found that someone had planted malicious code in the latest version of XZUtils. The code, known as a backdoor, would allow its creator to hijack a user's SSH connection and securely run their own code on that user's machine. At first, Mr. Freud doubted his own findings. Had he really discussed a backdoor in one of the world's most heavily scrutinized open source programs? For his digging, but his digging kept turning up new evidence. And last week, that's of course a few weeks ago, Mr. Freud sent his findings to a group of open source software developers. The news set the tech world on fire. Within hours, a fix was developed, and some researchers were crediting him with preventing a potentially historic cyber attack. Quote, "This could have been the most widespread and effective backdoor ever planted in any system product," said Alex Stamos, the chief trust officer at Sentinel One, a cybersecurity research firm. If it had gone undetected, Mr. Stamos said, the backdoor would have, quote, "given its creators a master key to any of the hundreds of millions of computers around the world that run SSH. That key could have allowed them to steal private information, plant crippling malware, or cause major disruptions to infrastructure, all without being caught." Nobody knows who planted the backdoor, but the plot appears to have been so elaborate that some researchers believe only a nation with formidable hacking chops, such as Russia or China, could have attempted it. According to some researchers who have gone back and looked at the evidence, the attacker appears to have used the pseudonym Ja Tan to suggest changes to XZUtils as far back as 2022. The attacker, using the Ja Tan name, appears to have spent several years slowly gaining the trust of the XZUtils developers and getting more control over the project, eventually becoming a maintainer and finally inserting the code with the hidden backdoor earlier this year. Since his findings became public, Mr. Freud said he had been helping the teams who are trying to reverse engineer the attack and identify the culprit, but he's been too busy to rest on his laurels. The next version of PostgreSQL, the database software he works on, is coming out later this year, and he's trying to get some last-minute changes in before the deadline. So I think that it is not, it's not hard to say, or it's not being overly being overboard saying that this was a huge find. But it furthermore introduces or reminds us that the internet is really a site that is being sort of held together by a bunch of volunteers, people who really are not folks who are being paid anything. They're volunteers. They're folks that are doing it for the love of code. And, unfortunately, and Linux runs everything. I mean, we think of Microsoft, we think of Apple's operating system, but when it comes to servers, unless you're on Azure software, which is run by Microsoft, you're on a version of Linux, and there are many, many different versions. And if this had run according to this, and this has gone on, and SSH is a way of logging in remotely to servers. Everybody uses it. I've used it. Everybody uses it. It's a standard protocol. And you use SSH because it is encrypted, so that when you log in, anything that you're sending back and forth to a server remotely has been encrypted, so that anyone who is observing or looking at what's going on that server, file transfers, data information back and forth, cannot see what is really being said, what is really being sent, what information is going across, because of the encrypted nature of SSH. So it is seen as the safest way to log into a server. So everybody does it. But if I cannot imagine a world in which SSH is compromised, because that would be the end of secure logging into websites, and that would virtually be the end of being able to run or manage a website. So fascinating story, interesting story, but people should look out to how vulnerable this system is. Thank you for watching today, and I hope to see you on the next one. Take care. Bye-bye.